Bill Henshaw again, your friendly local constitutional kook in California. And this video is going to be a big help, I think, in a lot of ways, because when you go into these courts, quote unquote courts, aka administrative tribunals that have no jurisdiction, and you get run over, and you know you do, whether it's an eviction, child procurement syndicate, anything like that, traffic court, I mean, all of it, BS. And we're going to get rid of all of it, working together here. But the big deal about that is I'm going to be doing for those who obtain my modestly priced constitutional defense document packet and send me an email, unincourt@gmail.com, about those. It's amazingly inexpensive, especially given what the damn attorneys charge for legal work these days. And you'll learn what to do here. And what we want to do, I'm going to do a short video, you can take with you and get to the presiding judge or the local dumbass or whoever and let them see who they're dealing with here. This is going to be a first impression, but, I say it with attitude, with authority, a cappella off the top of my head. I'm going to kick your ass and I'm going to laugh at you in front of the jury while I'm doing it. Simple. The other thing we're attempting to do here, since all they recognize are state bar association attorneys, aka those with titles of nobility, which you'll notice in Article 1, Section 9 and 10 of the U.S. Constitution are prohibited, aren't they? Joe Jackass Esquire. And these idiots are also unregistered foreign agents of at least the City of London, and they have irreconcilable conflicts of interest with any and all of the unopposed structural jurisdictional errors that I have to present and that you have a right to present from day one in the trial court. Even better in theory, if you were in a judicial court and you ain't been in one and you're not going to be, a neutral magistrate, that U.S. Supreme Court again, Toomey v. Ohio, 273 U.S. 510, has to dismiss the case, maybe in the first instance without prejudice, if the local dumbass doesn't prove jurisdiction, or whoever it is, the landlord, I mean, you name it. They have the sworn duty and they can't establish it. There's no way. They can't make service the process on you. You're going to learn all about that too. Another major big deal issue. And they have to do it. And even without a direct challenge to jurisdiction, and boy, are they going to get it up the wazoo with the materials I have. Send me an email, unincourt@gmail.com, and we will go from there. And what we want the judge to do is sign an order to the American Bar Association of necessary. All you recognize are state bar attorneys and or pro se litigants with their ever specious, frivolous, sovereign citizen arguments, aka the original intent of those racist framers. Then we're going to get the judge to sign an order to order, this SBA agent to come in there and take our paperwork and put it officially on the record, so they have to make a decision from day one in the local trial court, aka administrative tribunal. And that's what beats them, because there's no way, as you're going to learn, they can prove that you're a person subject to any and all allegedly applicable laws on the books, whether they're in Sacramento, St. Paul, Austin, Washington, D.C., you name it. They're not there. And that's going to get a lot of things stopped in the trial court. And pretty soon we're going to make a habit of doing that. And they won't even file cases like this anymore, which don't exist in an administrative tribunal. Whether you make a voluntary, knowing, and intelligent waiver of your right to a trial by jury according to the common law. There's that pesky Supreme Court again, Johnson v. Zerps, 304 U.S. 458. Where is it? And since they think we're at least in a guardian and ward relationship, if not dead birthright citizens, we'll learn all about that too in the 14th Amendment, we can't possibly make a voluntary, knowing, and intelligent waiver. And not only that, the perps did not make a full disclosure of any and all terms of the allegedly applicable agreement to you at the time. Unenforceable in a common law court to which you have the right from day one. It just gets better and better. It's amazing how good of a job they did in 1791 to put all this together. And no, it wasn't a perfect government, but only the best one ever created. We want it back. And we have justices on the Supreme Court now that have the same goal. They might not get there quite as fast as we would like, but they're going to be ready, I think, to put the pedal to the metal after Inauguration Day and make some serious rulings. And we'll talk more about that in other videos. But that said, send me an email, youwinincourt@gmail.com. Tell your friends, get the word out. The quicker we take action, the faster we get these bastards off our backs. Thank you.